SJC-12150, 477 Harrison Avenue, LLC v. JACE Boston, LLC, and another.
Thanks.
Good morning, Mr. Furman.
Good morning, Your Honor. May it please the Court, my name is Mark Furman. I appear today on behalf of defendant appellants, JACE Boston LLC and Arthur Leon. The plaintiff in this case, 477 Harrison Ave, brought a two-count complaint for abuse of process in 93A against the defendants based upon defendants' petitioning activity. The defendants brought a special motion to dismiss in the Superior Court, which was denied, and the defendants asked this court to reverse that decision of the Superior Court for three reasons. First, the plaintiff's claims are solely based on the defendant's petitioning activities. The core of claims of abuse of process are, of course, petitioning, and that's the basis of the claims in this case. Second, the Superior Court was incorrect in deciding that the petitioning activity itself of the defendants could be the substantial other basis for abuse of process type claims, and by considering the motive of the defendant at the first prong stage. And third, the non-moving party failed to meet its burden on prong two and established that there was no reasonable basis in fact or law for the defendant's petitioning activity. And there was a very substantial record below as to the reasonable basis in fact and law of the petitioning activity, which was essentially unrebutted below. This court...
Can I ask you, how does an abuse of process claim survive a special motion to dismiss under your analysis?
Prong two, Your Honor. That's what saves. So it's only...
So what's a valid abuse of process case in your view?
When the process is used without a reasonable basis in fact, or the process is used without a reasonable basis in law, the special motion to dismiss should be denied. This does not, this approach, which I believe is consistent with the approximately 6, I think, abuse of process and malicious prosecution cases decided by this court since 2000, does not abolish abuse of process, but it protects petitioning activity where there's a reasonable basis for it, both in fact and in law. And
What about the application for the complaint, criminal complaint? That's kind of the basis, one of the bases of the abuse of process. That's...
Yes, Your Honor. That's a prong two analysis. It's not a prong one analysis. It's clearly petitioning activity, making the application, as this court so held in Wenger, and there is, so it satisfies prong one. That's not the end of the analysis, however.
They don't say that. Your brother says it's in response to your harassing litigation and in response to seeking a criminal complaint in the Boston Municipal Court as it relates to prong one, and that it's not based on petitioning activity.
Our position, Your Honor, is it is based on petitioning activity as this court has viewed based on since the Duracraft case. The focus of the two-prong analysis is to not consider motive at prong one. The focus, as this court has repeatedly said, is it based on petitioning activity or is there a substantial other basis? And the court repeatedly has said motive is irrelevant. But now you have to go to prong two. And I'm happy
Judge
to...
Curran never reached prong two, I don't believe.
I'm sorry?
Judge Curran never reached prong two.
He did not reach prong two, and there was no evidence below that could possibly meet the defendant's burden on prong two, including, Your Honor, with respect to the application for criminal complaint, which I'd be happy to speak to.
Does the statute protect petitioning activity ad infinitum? I mean, can you go on with this for 10 years and still have the protection of the statute? I mean, are there any limits that are there or should be there? This case comes pretty close.
Well, Your Honor, there really is, I don't think it does, Your Honor. There was an appeal of a zoning decision in 2012, and the zoning relief was not pursued, so the case was not decided. My client is an abutter who is presumed to have standing under the law, and while that standing can be rebutted, the factual underpinning here, Your Honor, which is undisputed, my client doesn't have a wall where its property intersects abuts the defendant's property, but it has a right under an easement that was granted in 1926, and my client's property is held up by 20 steel beams that tie into that wall, has a support right. The plaintiff's intent was to demolish the wall in the area in which my client claimed an easement, in which the Superior Court and the unanimous three-judge panel of the appeals court affirmed my client had those rights. That was the 2012.
But aren't we dealing with a motion to dismiss where we are supposed to credit the plaintiff's allegations at this stage or take them at face value? And included in those allegations are an ulterior economic motive by your client, correct?
Ulterior motive has been held not, Your Honor, to be part of the analysis under prong one.
I understand your position, but if we look at the plaintiff's complaint, there's those statements allegedly made to the relative about, trying to get the property for their own economic benefit, correct?
Well, the allegations in the complaint as to these one conversation in January of 2012, long before these cases were brought, I don't believe have evidentiary value as to that, but they do allege that in the complaint, Your Honor. I was speaking to the, whether or not this is like piling on.
No, in fairness,
and I think the record.
Your client has won at some point along the way, right? I mean,
Well, there was an agreement for judgment in case one. There was a judgment in my client's favor in case two. The record is filled with our reasonable basis in fact and law for the application by my client for the criminal complaint, which appears extensively in the record below, and which was not, which included pictures. There was no permission to be on the property at the time they were on my client's property.
Was there a clerk's hearing in the district court, section
There
30?
was, Your Honor.
All right, and the clerk decided not to issue a complaint, is that right?
Stating that my client should go to the Superior Court.
Yeah, I have to say, I share Justice Hines' concern, and I'd ask you, why isn't seeking a criminal complaint against Mr. Holland? That's a pretty draconian thing, a substantial basis other than petitioning activity.
I think, Your Honor, it's petitioning activity is our position, and the claim is solely based on petitioning activity, and that the proper analysis should be was there a reasonable basis in fact and law, which is the analysis this court did in the Wenger case. And when you look at the record and all the pictures of what was going on and the correspondence between the parties in the fall of 2014 that appears in the appendix at 724 to 747 and 752 to 757, it is clear, we submit, that there was a reasonable basis in fact or law. There needs, Your Honor, in my view, to be some predictability for when people petition the government when they're going to be sued. And the two-prong analysis established by this court, where motive is not considered at prong one, is what protects the rights of citizens to petition the government when they have a reasonable basis to do so, both in fact and in law. And in this case, there was a reasonable basis in both fact and law for each of the cases.
If I can move you a little bit. Let's imagine there was no anti-SLAPP law.
I'm sorry, Your
Let's
Honor?
imagine there was no anti-SLAPP statute. For abusive process, is an element of abusive process that the claim brought was frivolous?
At common law, no, Your Honor. I don't believe that was
So, and so essentially then, what you are saying is that the statute effectively amended the common law and said that now to prove abusive process, they must prove that it is frivolous, meaning devoid of reasonable basis in fact or law, as well. That's what they need to get past the anti-SLAPP motion, correct? If they were to prove that your petitioning activity was frivolous, you would lose, and the motion to dismiss would be denied, and they would carry forth, and then they have to prove ulterior motive as well as it's frivolous, correct?
Yes, Your Honor. I wouldn't use the word frivolous, but I take your
Okay, I mean, is it materially different from
Maybe.
Chapter 231-6F
It's-
finding? I mean, is it going to be, in terms of the, are we going to look at it any differently than we would if they had moved to just, if they had said that we prevail and we ask for attorney's fees under 231-6F?
It's a preponderance of the evidence standard, but yeah, I take your point, Your
I mean, it's
Honor.
close enough.
Yes,
I mean, it may
yes,
be a
it
little
is.
bit different because it's devoid of merit, and that may not be the language, but it's pretty close. So essentially, what you're saying, I gather, is that they must show to prevail that your petitioning activity, meaning the claims you brought in court, were frivolous. And if they prevail, then they survive prong two, and you go to trial.
Yes, Your Honor.
So essentially then what has happened is that the legislature has effectively revised the common law concerning abusive process by effectively saying to prevail on a motion to dismiss, they must prove that your claims are frivolous, and at trial, they must prove both that your claims are frivolous and that there was no ulterior motive in your bringing it. Is that basically the law you're asking us to adopt?
Yes, Your Honor, I am. And I think adopting that law, not all cause of actions are the same, needless to say. And there are some of the cases involve civil rights claims and other types of claims where the analysis is different than an abusive process case, which by definition has an essential core, the use of process. And yes, I do think the legislature did balancing wanting to encourage people to be able to petition the government and but wanting to preserve abusive process by virtue of prong two. That's the appropriate balance. It gives predictability, and I'd say one way to look at it is that if you take the petitioning activity out of the case. Is there a claim? And suggest when you deal with abusive process, there is, in some situations, that there would still be a claim. I recall, a civil rights claim where there was harassment, but of different sorts. That's a different analysis where it didn't involve petitioning activity, but this case deals with petitioning activity. So
So what's the remedy then if a litigant has an ulterior or illegal purpose involved in what they filed based on trying to reconcile abusive process with anti-SLAPP?
they had a good faith basis for the claim, both in fact and in law, and the claims based on petitioning activity, the special motion to dismiss should be allowed, Your Honor. It's our view.
All right, thank you.
Thank you.
Mr. Gallowboy, good morning.
Good morning. May it please the court, Andrew Gallowboy on behalf of the plaintiff and appellee, 477 Harrison Ave, LLC. We ask this court to affirm Judge Curran's denial of the defendant's special motion to dismiss pursuant to the anti-SLAPP statute, as Judge Curran did not commit an error of law or abuse of discretion in denying the motion.
Were their claims frivolous?
Some of them were. The criminal complaint was certainly frivolous, and we believe the other claims were also frivolous to the extent that they were contrary to
Let's assume, I guess that's a question of whether or not if you lose, it gets remanded, or whether, you didn't argue that it was frivolous.
We did not argue. We argued that the claims were brought against Jason Leon's own interest, which by definition would be devoid of fact or law, which would render them frivolous under the analysis set forth there in my brother's argument.
So you say you did implicitly claim it's frivolous, and the judge never reached that prong too?
Correct, Your Honor, as he found that the
Okay.
defendants failed to satisfy.
If it turns out that those claims were not frivolous, could you still prevail on your anti-SLAPP?
Yes, Your Honor, because anti-SLAPP is only for claims that are based on petitioning activity. And in this case, Judge Curran pointed to the Durcraft decision where this court said there's a difference.
But I mean, of course it's based on their petitioning a court for relief. How could it not be? What else is it based on except abusive process isn't by definition, you have to bring a claim?
Certainly, Your Honor, but I think in what this court said in Durcraft is there's a difference between based on and in response to. And what I would say in response to is the surrounding circumstances of what led you to the filing of the abusive process claim. And based on is simply you filed X, so I've sued you now, which is the standard case that often presents itself to the court, is where one person engages in one act, such as filing a restraining order, then is sued for abusive process. Here you have a multi-year history of petitioning activity across the spectrum of every sort of level of administrative and judicial form you could find yourself in.
Okay, so let's imagine that you are a oil company trying to open up offshore drilling, and there's an environmental group who is battling to prevent you from doing so and brings various claims against you, none of them frivolous, all designed to prevent the drilling from occurring offshore. Would they survive an anti-SLAPP motion, even if their claims are not frivolous? Because their motive is plainly to prevent you from doing what you want to do?
Potentially, depending on the outside factors, but also where you said the motivation. Here you have clear statements by the defendants stating that they do not want the plaintiffs to be able to do what they intended.
And imagine there were clear statements from the environmental group saying we don't want there to be offshore drilling off of Cape Cod.
Sure, and it would not be for the environmental group's economic benefit in any way, shape, or form. It wouldn't be for the environmental group's economic benefit.
At the issue, we need to look to see whether or not there's a financial, maybe it was being financed by hotels, it was being financed by hotels on the Cape who feared that the risk of pollution would hurt their business. That would matter?
It could be in the deeper dive to determine whether it's based on or in response to, and I think Justice Gaziano in his decision in Mantell as a Superior Court justice pointed out, there is no bright line rule. It's a case-by-case factual analysis to reach that determination.
But there is a standard.
Correct, Your Honor.
So why should the standard not be that you need to show that it's frivolous?
Because
And if it's not frivolous, you can't do it.
Because I think that would lead to the anti-SLAPP statute displacing an abusive process claim. Because the law...
Can't the legislature do that? Can't the legislature by statute say we're going to override common law and say that we believe that I haven't gone back to my abusive process law, but is it conceivable that you could say that I win on abusive process even though I make a perfectly valid claim and I prevail at trial, but I do so with an ulterior motive that the court views to be improper, so that, is it unreasonable for the legislature to say we don't want that to be what the common law says?
I don't believe it would be unreasonable if that's what the legislature had said. I don't believe they've said that. Justice Cordy, in his concurring opinion, Benoit, said he thought it would be constitutionally suspect for the anti-SLAPP statute to displace the process-based torts.
It would be unconstitutional for the legislature to say we believe that an element of abusive process must be that the claim is frivolous?
But the answer to that question is no, but I don't believe the language of the anti-SLAPP statute changed the elements of abusive process claim.
Well, hasn't it?
I don't believe
effectively?
so. I don't believe so, and as the abusive process cases and claims have continued in the Commonwealth over the last 20 years since the anti-SLAPP statute was passed.
Right.
So,
And you agree that you can survive an anti-SLAPP motion and you can win
correct.
if you show it to be frivolous.
I don't believe that's the only way to win. That's the prong two analysis.
Okay, so your view is that you can prevail if the petitioning activity is perfectly appropriate, has a reasonable basis in fact and law, you can still sue them for bringing that claim.
I believe you can if a court reviewing a anti-SLAPP motion makes the factual finding, as Judge Curran did, that it was repeated at times meritless and harassing. And then also, and this is, I believe...
But he didn't find it meritless. He found it harassing.
Oh, his statement was, the defendant's repeated use of process at times found meritless, as was the case with the criminal complaint, in a harassing manner. So I think that's a factual finding he made upon reviewing the amended complaint, which is a 30-page, 132-paragraph amended complaint. But also that allows me to pivot to the second path to affirming the judgment.
Before you do that, this litigation is not a monolith. And in fact, the defendants succeeded at various points in time. Why isn't it, whatever you want to say about comments that we take as true for the purposes of today in the complaint, doesn't the defendant, where you have this common wall, have a right to litigate the issue of an easement?
If their motives are pure, they have the right to move forward. If their motives are ulterior or have an illegitimate purpose, it opens the door for an abusive process case. And here, with respect to the easement, it's illusory. It's an easement that can never be exercised. It was strictly to follow along with his stated goal of delaying the project, forcing redesigns of the project, or extracting concessions from 477 Harrison. It's an easement that cannot be used. It's alleged in the amended complaint that it can't be used, supported in the affidavits. Again, at this stage of the case, that should be credited. So, and that's what leads to the second path to affirming Judge Curran's decision, is that you do have independent conduct separate and apart from the petitioning activity that mandates the denial of a special motion to dismiss. You have the repeated statements by Mr. Leon outside of any petitioning activity to his cousin, saying that they paid too much, they were going to go bankrupt, and he was going to buy the building for himself from the bank. You have his statements that he wants.
Those statements are not abusive process. There's no process involved in those statements. So you made no claim of defamation. So how are the statements actionable?
Well, I think the statements are independent conduct. I don't think they need to be part of the process. The appeals court recently in the Allied Waste case found that an abusive process case survived where the independent conduct was one party leaving its machinery on the other party's property. I think independent conduct is independent conduct. It doesn't have to be strictly a process-based activity. Otherwise, you could never satisfy prong one. And the appeals court in the Adams case said the purpose of prong one is essentially to save abusive process cases. So when you have...
Don't the statements just go to his motive?
They're also independent conduct, and this is what we discuss at length in our brief, the Keystone case, which discussed the interplay between abusive process and the anti-SLAPP statute. To proceed with an abusive process case, you must plead that they've engaged in processing activity with an ulterior illegitimate purpose. If you allege facts that support both, they shouldn't be disregarded. They just count for independent conduct in the anti-SLAPP analysis, but also satisfy your pleadings obligations with respect to if you face a 12b6 motion. In many respects, I think it's almost as if there's a heightened pleading standard where you need to allege actual facts supporting the ulterior motive or illegitimate purpose. You can't just say they file a process for an ulterior motive or illegitimate purpose causing us damages. You need to set forth facts which can also be independent conduct and the ulterior motive. And that's exactly what we have here. These statements absolutely evidence both independent conduct and ulterior motive. And there's nothing wrong with that. There's no case that says
What
you
is
should...
the claim based on the independent conduct? What is your claim in the complaint? I haven't looked at it, so I need to know, is it related to abusive process, or is there another claim that would cover that independent conduct?
It would relate to the 93A Section 11 claim that these are unfair business competitive tactics deployed by a competing real estate developer to delay and try to derail a project. I don't think you can essentially call your shot, say, I'm going to stop this development, and use process to advance that goal when you say, I want to buy the building. I want you to redesign your building. I want you to delay your project so I can design a project and go first. Or when your agents say, our whole purpose was to stop you, delay you, or force you to redesign your building. Or when I say, I can't allow you to have the penthouses because the people who buy them will have enough money to obstruct my development. Those cannot give rise to legitimate claims, and those are not legitimate business tactics, and they're certainly all independent conduct that would mandate the denial of a anti-SLAPP motion because there's a substantial basis other than petitioning activity. And the fact that you have repeated examples of it shows that the statements are both go to independent conduct and motivation. But beyond just the statements, we also have the concession in their briefs that the filing of insurance claims against 477's contractor are non-petitioning conduct that we allege were designed to harass.
Now, speaking of motive, your motive is to prevent them from bringing these actions.
No, this is absolutely a meritorious suit where our motive in bringing this is to seek redress for the damage that has been done.
Okay, but your motive is you want to stop them from suing you.
We would hope they would stop them from suing us because we have meritorious claims against them, which Judge Karn says can proceed to pass the initial pleading stage. But the goal in this case is to recover for the damages that have been caused.
Isn't that with regard to every legitimate, every true SLAPP claim, isn't that its purpose, is to impose upon the other side the cost of litigating and the potential cost of losing, and therefore discourage them from petitioning?
No, Your Honor. I think the court has said in Duracraft the purpose is not to win. Here the purpose is absolutely to win. The fact that they now have to endure costs to defend a meritorious action is not the main goal of the lawsuit. It's necessary because there's a lawsuit now, but it's to seek redress for the damages caused, the loss of the penthouses, the loss of the second floor residential unit, and that's the purpose of the lawsuit. And it's shown by the fact they filed another lawsuit after this case was filed. So the idea that this somehow chilled their activities or...
Well, wouldn't it chill? And let's assume that they had a valid claim, a non-frivolous claim. Wouldn't the prospect that they're going to now have to pay for your economic loss chill their ability to bring that claim?
It did not.
Well, it arguably would if you win. I mean, going forward, if somebody is going to say, I'm trying to stop a development next door, but if I do that, I have to worry they're going to sue me for abusive process, and I'm going to have to pay for the loss of the developer's lost profits, then that's going to bankrupt me, and therefore I can't afford to fight this development, and I can't afford even to litigate it.
That would only be analogous if that person had also engaged in the pattern of conduct that we have here, where they've stated that they have these economic motives. They want to delay the project, stop the project, cause redesigns. This is not a case aimed at an ordinary citizen who's concerned about a big house being built next to him. This is a multimillionaire, sophisticated real estate developer, you know, with access to attorneys, engineers, architects, who has brought the fight to my client. So the idea that this would somehow open a cavalcade of lawsuits against ordinary citizens.
Well, I mean, let's imagine, I mean, I know there's a development, let's imagine there to be a development in Boston which is going to be tall, sufficiently tall that it's going to be denying light to a neighboring residential skyscraper. And that developer says that's going to diminish the value of my house because there's going to be no morning light for those folks, and therefore I'm going to battle it. Economic motive, they may have a perfectly valid ground to say that under zoning laws or whatever, you may not build a building that tall. Under your theory, you'd win.
It would be decided based on the facts. Were there discussions of, we only want to oppose this to extract something out of the developer, we hope that we can stop the project so we can buy it and advance it? That's the analysis we engage in, and our complaint sets forth independent conduct that evidences the impure motives and the ulterior motives and illegitimate purposes.
So then you're basically asking a judge in a motion to dismiss to divulge the true motives of all the people involved? That's a rather challenging thing to ask a judge to do for a motion to dismiss, isn't it?
I don't believe that's what we're asking the judge to do. We're asking the judge to review a complaint, analyze the allegations, and determine whether the complaint alleges conduct beyond just petitioning activity. And in this case, it absolutely does.
Why is that? Now, why aren't the appellants right? Why aren't we at prong two? Since the gravamen of the complaint here ultimately flows out of the defendant opposing a variance. So why aren't we at prong two?
We're not at prong two because in this case, the trial court held that they had engaged in such repetitive, harassing, and at times meritless litigation that it was not, the action is not based on the defendant's petitioning activity, but it's in response to. And this is consistent with footnote 20 of Duracraft, what this court said in the matter of discipline case, then the appeals court's discussion in Adams, and then Justice Gaziano's decision in Mantel, that there is no bright line rule, that there is a case-by-case factual analysis based off the allegation of the complaint to determine whether petitioning activity alone can be coercive or abusive enough to survive a motion to dismiss.
No 20 limited to counterclaims?
I don't believe so. The statute says claims, cross-claims, and counterclaims. I don't read footnote 20 as exclusively maintaining or referring to counterclaims.
But assuming that we decide you should get to prong two, I assume you say you win.
Correct, Your Honor. I think in a case where the petitioning activity is counter to the stated goals of the petitioner, or do not advance their purpose at all, but of attaching their building to another building, but advance their stated ulterior motive of stopping a development, that when there's a situation where the litigation is not to their benefit, that it has to be devoid of fact or basis in law. And I don't think the court's ever been confronted where a litigant has brought a case, that's contrary to their stated interests. That's certainly not reasonable behavior, and it's certainly not behavior founded in fact or law to engage in that kind of conduct.
Okay, thank you.
Thank you, Your Honor.